A man stands in a Louisiana courthouse in 1866. He has walked out of slavery months before. He has bought a small plot of land with money saved and earned. He has built something. But today, a state official places papers in front of him. The papers say he cannot enter a contract. The state has decided he is not a citizen. The world he thought was opening closes again, not through chains, but through the simple mechanics of law. This scene repeats across the South in different variations. A freedwoman denied property rights. A freedman barred from testifying against a white man. A black laborer locked into contracts that look voluntary but operate like servitude. The 13th Amendment had ended slavery as an institution, but it had not ended a state's power to decide who counted as a human being in the eyes of the law. Southern legislatures understood this gap perfectly. They wrote codes that appeared neutral, regulations about labor, contracts, property, movement. The codes were written in the language of general law. Their function was specific, to restore in everything but name the legal structure of slavery. This was the crisis the 14th Amendment addressed, not with poetry or moral appeal but with a structural shift in power. For centuries, citizenship had been a state matter. A state decided who belonged, who could own, who could testify, who could move freely within its borders. The federal government had limited reach. The 14th Amendment reversed this hierarchy. Its opening words established that anyone born in the United States was a citizen, period. No state could erase that. No state official could hand you papers saying you didn't exist in law. But citizenship alone wasn't enough. The amendment required states to follow due process, fair procedure, before taking away a person's life, liberty, or property. The language echoed older documents that had applied only to the federal government. Now those limits applied to the states themselves. They could no longer move against people arbitrarily. They had to follow their own rules, and they could not write laws that protected some citizens while denying protection to others based on race. Equal protection of the laws became a constitutional requirement, not a request, a requirement. The federal government enforced this with occupation, with troops, with conditions for readmission to the Union. Southern states had to ratify or remain outside. Congress claimed explicit power to enforce the amendment, a transfer of authority that Southern legislatures found intolerable but could not prevent. Yet the words on paper did not instantly change the world. Courts interpreted the Equal Protection Clause narrowly for decades. Segregation persisted. Discrimination continued. The amendment's text remained stable while its meaning shifted case by case across more than a century as courts and society gradually moved toward what the words had always said. What changed was fundamental. The question of your rights moved from state legislatures to constitutional principle. You were a citizen first. Your state could not undo that. That hierarchy, established in 1868, remains the foundation of every civil rights claim made today.